Y'all, this case just keeps getting wilder and wilder. This morning, on the second day that the jury is back, Woody's attorney Melnick has been suspended from practice by the Georgia Supreme Court. He is now suspended and cannot represent Woody, okay? He's suspended for 6 months. There is a whole decision, it's 24 pages long. What I'm going to just do is read the factual background, which should give the facts as to what led to Melnick being suspended. So bear with me, y'all. Let's get into this. Again, Melnick is now suspended. Factual background. The following facts were either found by the special master or were established without dispute at the hearing. Melnick has been a member of the state bar since 1994. He received 2 investigative panel reprimands in 2003 and an investigative panel reprimand in 2006. All 3 matters involved violations of Rule 1.4 and 2 involved Rule 1.3 violations. In May 2017, Melnick began representing a client in a matter filed in Rockdale County by the father of the client's child. The father was paying child support via an income deduction order and was seeking a reduction in child support, as well as to legitimate the child and obtain visitation. During that time, Melnick was a solo practitioner with no full-time staff and no case management software. He handled between 50 and 80 cases at a given time and was in court 17 out of 20 days each month. He used a software program to manage his calendar and communicated with his clients primarily after typical business hours. In 2018, Melnick, his client, the father, and the father's attorney participated in a voluntary mediation where the parties were able to reach an agreement on a reduction in child support. However, the parties still needed to agree on visitation and prepare a parenting plan. The parties agreed that the father's reduced child support payment would become effective April 1, 2018, and that if a new income deduction order was not in place by April 1, 2018, Melnick's client would reimburse the father each month for the difference between the child support amount paid pursuant to the income deduction order and the reduced amount agreed upon at the mediation. After the mediation, the parties notified the court that they had reached a settlement and would be submitting a final order, so the court removed the case from the trial calendar. The father's attorney emailed Melnick a draft consent agreement about a month after the mediation and asked that Melnick's client begin reimbursing her client for the child support overpayment. Almost a month later, Melnick responded, quote, "Please call me," unquote. The 2 attorneys exchanged a few emails during May and June about a visitation schedule and the amount of the reimbursement. In early August, the father's attorney sent Melnick a revised consent agreement with a parenting plan included. A week later, Melnick responded that the parenting plan was fine, but that he, quote, was not going to agree to a refund of the child support since April. The father can take that up with the child support, end quote. The following day, a Friday, Melnick emailed the father's attorney that he believed that it would not be proper for his client to send the reimbursement to the father's attorney. The following Monday, the father's attorney filed a motion to enforce the settlement agreement. The motion also sought an award of attorney's fees for having to file the motion. Melnick did not send his client a copy of the motion or otherwise inform his client about it. He also did not file a response to the motion because he felt it was, quote, unnecessary. Melnick planned to handle the attorney fees issue at the hearing and believed he could prevail pretty easily on it. The trial court scheduled a hearing on the motion for January 8, 2019. Melnick did not tell his client about the hearing. Because he had a conflict for that date, he emailed a conflict letter to the judge's administrative assistant 5 days before the hearing was scheduled in an attempt to comply with Uniform Superior Court Rule 17.1. While the judge's assistant acknowledged receipt of the conflict letter, Melnick did not follow up with the court to determine if the hearing had been rescheduled. The court conducted the hearing on January 8th. After Melnick was finished with other matters for which he was scheduled to be in court that day, he called the court and was told the hearings were done. He did not ask about the outcome of the hearing and did not contact his client to tell her he had not attended it. Sorry for laughing, y'all. This is crazy. On January 15, 2019, the court issued a final order enforcing the settlement and ordering Melnick's client to reimburse within 30 days $2,820 to the father for child support overpayment, as well as $809.93 in attorney fees related to the motion to enforce. After the trial court issued the January 15th order, Melnick did not notify his client about the order and did not tell her she had to pay $3,629.93 within 30 days and did not send her a copy of the order. The client became aware of the January 15th order when, after the amount she was receiving in child support decreased, she went to the courthouse and obtained a copy of the order. That was also when she became aware of the January 8th hearing and motion to enforce. Melnick never filed a motion to withdraw from the case, nor did he terminate his representation. The client retained new counsel who contacted Melnick and raised the possibility of the client filing a malpractice action against him. Melnick discussed settlement with the client's new counsel, and after the client filed a grievance with the state bar, Melnick paid the client $3,500 and obtained a release. So there you have it, y'all. Melnick has been suspended. I just read to you the facts as the Georgia Supreme Court has enumerated them. So, questions. Now that he's suspended, who is representing Woody? This didn't even seem to come up in court today. This just hit the internet thanks to Thugger Daily. Y'all, of course, if you are not following Thugger Daily on X, get on X, follow Thugger Daily. He's doing an excellent job. But we don't know how this might affect Woody. We saw yesterday that Woody had to have a conversation with Melnick about his rights, about the immunity. He has to rely on his legal representation. And as of right now, nobody knows who's representing Woody. What might this mean for the YSL trial? Might Woody be able to claim inadequate legal representation due to this suspension? This, after all, now Melnick is an attorney who is now suspended. Who knows, y'all? So everything is kind of up in the air. But again, here we have it. Attorney Melnick is no longer Woody's attorney, at least not practicing, because he's suspended for 6 months by the Georgia Supreme Court.